Good morning and welcome back to the 15th meeting of this committee in 2021. And this is an evidence session with the First Minister of Scotland, Nicola Sturgeon MSP. I can confirm that the First Minister took the affirmation at the start of this morning's evidence session. Before we suspended, we were discussing the theme of complaints handling. We'll stick with that, and I therefore go to Alex Cole-Hamilton.
Thank you very much, Convener. Good morning, First Minister. Thanks for coming to see us today. I'd like to continue the theme of discussion around confidentiality around complainers. But before I do, I have a couple of very specific questions, just around the way you phrase things, because I think that words matter. And I was very struck that in your opening statement, to describe the revelation of the investigation, you used the phrase that I think you always have done since these allegations came to light, and that is that Alex Salmond informed me of the investigation on the 2nd of April. Do you accept that there's a difference between having knowledge of a specific complaint and investigation and having awareness that someone might have come forward with a concern?
Yes.
Okay. With that in mind, can I ask, when did you first become aware that a civil servant may have come forward in 2017 with a concern about historic behaviour on the part of Alex Salmond? Not a formal complaint or an investigation. When did you just have awareness of that as a reality, that somebody had come forward?
So and I'm not trying to play with words here. I'm going to try and answer your questions as directly as I can, based on my recollection of conversations that I had. We'll come on to the 29th of March. So I, partly from the November Sky query, which we may or may not come on to, and then my conversation with Jeff Aberdeen, I had an awareness that there was an issue with concerns about Alex Salmond and that they may be in the form of a complaint. But it wasn't until I read the Permanent Secretary's letter on the 2nd of April that I knew beyond any doubt that any general concerns or suspicions I might have had actually became detailed in actual knowledge of the fact there were 2 complaints, that there were by civil servants, that were being investigated under that procedure, and what the nature of the complaints was.
So if it was just about Sky News in the airport, that wouldn't have actually been a complaint in your government. But, so just to be crystal clear, you did have awareness that there might be a concern raised within the civil service about Mr Salmond in or around that time.
So from the 29th of March, and this I think is a distinction from the 2nd of November, the 4th of November, I think that query was, I had, and we'll come on to this, and it's a frustration for me, my recollection of the conversation with Jeff is not as vivid as I wish it was, which I think perhaps tells its own story. But I came out of that and went into the 2nd of April meeting.
I will ask you about the 29th of
March
but later on. Okay,
I'm trying to answer your question.
Yeah,
so
of course.
What I'm saying to you is, ahead of the 2nd of April, I had an awareness there was a complaint. No doubt I had suspicions of what the nature of that might be, but that's what it was, a general awareness, a suspicion that no doubt I had all sorts of theories for in my head, but it was reading the Permanent Secretary's letter that he showed me on the 2nd of April that gave me the knowledge and the detail behind that knowledge of all the things that I've spoken about.
And forgive me for interrupting there. No, and that comes back to that distinction between knowledge of a complaint and awareness that something might be going on. Can I just, final question on this bit, did you have awareness before the 29th of March that there might be complaints or concerns emerging within the civil service?
Not specifically, but again, this relates, and I know you've, I think, heard some of this from the Permanent Secretary. So, the 4th of November Sky query that I spoke directly to Alex Salmond about on more than one occasion over a couple of days left me, for a variety of reasons that I can go into or not as you wish, with just a sense of unease. I can't put it any more strongly than that. One of the reasons I think that led to that was that I had been made aware, just for the chronology of this, the Sky query came in on a Saturday night. I spoke to him on the Sunday. I was made aware on the Monday that him and or his lawyers had been phoning people within the civil service, and I spoke to him again about that. And I can't put this any more firmly than I'm about to put it to you, and I'm sorry about that. That, and the way that that was raised with me, just led to a sense of unease that him phoning, or these phone calls, whether they're from him or his lawyer, had stirred something, kind of poked a hornet's nest. So I didn't have knowledge of specific complaints, but it wasn't something I thought about every day. It wasn't something that I lay awake at night at that point worrying about. But I had a lingering suspicion that there just might be something in the ether, in the undergrowth, that could surface.
Okay, thank you. I think the reason I ask about your phrasing is because when all this broke in the media, you gave several calculated and selective answers on national television to people like Sophie Ridge and Andrew Marr, and then had to reverse those positions when certain information came to light. Can you see why people might feel misled by your description of these events?
So looking at this as, I was going to say dispassionately, but that's not the right word because that's not something that's possible for me to do. But yes, I can. And to try to explain things, again, as openly as I can. Firstly, this is all stuff that, and I don't want to labour this because it's not of any interest to the committee, and it's not me appealing for sort of special treatment here. This stuff's deeply personal for me, and it's really quite hard to talk about. And at times, if I have appeared as if I'm cagey about it, that's one of the reasons. One of the other reasons, you talk about interviews with Andrew Marr and Sophie Ridge. I don't think this is true of the Sophie Ridge one, if it's the one I'm thinking about, but certainly Andrew Marr, at the time he first asked me about this. At that time, what was also I was very conscious of is that there was an ongoing investigation. I was really, really worried that anything I said about this at any time would cause headlines, news, commentary. I was always trying to avoid doing that. So if I appeared as if I was not being as kind of open and discursive and full, that was another of the reasons. The other point about the Sky thing and why I didn't, I think it's a point Glenn Campbell has made as well, when the government investigation process became public, that I didn't refer to that. Although that had left me with lingering suspicions, at that point, that story had never run, it had never surfaced. As far as I knew, there was nothing to it, although, you know, I did have some concerns that there might be something to it. So I had nothing to base that on beyond what I'm telling you here. So, yes, I do understand why people might see that. And I would just say to people that there are a lot of factors here, not least, you know, I've seen commentary to the effect that I always seem really uncomfortable when I speak about this. I am really uncomfortable when I speak about this. We were talking here about serious allegations that have led to the breakdown in a relationship with somebody that was really important to me on all sorts of levels. So I do feel uncomfortable when I speak about this at a human level, but I'm not here to talk about that. I'm here to answer questions as First Minister, and I am trying to do that.
I appreciate that, First Minister, but you understand that this comes to the very heart of what we're considering. Your knowledge of these events really matters, and the fact that you had to reverse your position of what you knew and when on Andrew Marr has left people with some considerable doubt. I will move on.
Can I,
yes,
forgive me, just the other point about Andrew Marr, and again, you know, I appreciate people watching this may not see this. I think when Andrew Marr, you'll be loving the fact that he's featuring so heavily in this discussion right now, when he came back to ask me this, I think I made the point that I felt two issues were being conflated. I thought the question I was answering the first time was around the Scottish Government complaints, whereas what I had previous knowledge of was the Sky query, which is a different thing. So sometimes one of the other reasons here is that different things have been conflated when they are actually separate.
Okay. I'd like to move now to the issue that Murdo Fraser and Jackie Baillie were discussing with you before the break about the confidentiality of complainers. And we have had it corroborated, the assertion that a name of a complainer was given to Jeff Aberdeen. If true, that's an egregious breach of confidentiality. And you told Jackie Baillie that you don't accept it. You confirmed that you'd spoken to the senior official who's accused of this when you learned of it. Is that the reach of your investigation into this issue?
I know that, so at the moment, I am trying to respect the other investigative processes that are underway here. I know that I can't speak for Jeff Aberdeen, but I know that James Hamilton has an account of this, and as I say, it's up to the committee to decide what it does. Can I just... Jackie Baillie suggested earlier on that I had somehow contradicted myself today against what I said last week at First Minister's Questions. I have the official report here, and I did not. What I said was not that I didn't have knowledge of this allegation. What I said was that, to the best of my knowledge, the allegation wasn't true. I can read the official report should anybody want me to.
That, with respect, James Hamilton is investigating your actions, not those around you, but he might have a judgment to make on those as well. We will discover that. Nevertheless, it is a sackable offence to breach confidentiality in that way. So would you be surprised that the senior official that you asked about this as the reach of your investigation denied it?
Look, I'm not sure, Convener, I can say much more about this than I already have, and I've tried to be as expansive as possible within constraints. What I do know is, I mean, we're talking about breaches of confidentiality and GDPR, and actually I think these issues are even more fundamental than that. I don't disagree. If this happened, it would be as serious as you're saying, but I've set out why I am not sitting here accepting as fact that that happened, because I think there is an alternative explanation of that. But I can only, in talking about GDPR and confidentiality, the person who told me the identity of certainly one complainant, and certainly gave me the impression he knew the identity of the other, and I can't remember if he told me the name, was Alex Salmond.
Final question on this bit, and then I will move on, I promise, Convener, to other aspects of confidentiality. I mean, this revelation, if it happened, well, it clearly knocked Jeff Aberdeen for 6. He had a telephone conference with Kevin Pringle and Duncan Hamilton. We also understand, I believe, that he reached out to a former civil servant who he was very close with as well, clearly reeling from this. Yet, I understand you've not attempted to contact any of them?
I haven't attempted to contact Jeff Aberdeen about this, because I think if I had, and I was sitting here saying that right now in front of this committee, I would probably be getting criticised for... I mean, I don't have it in front of me, Convener, but, you know, the initial letter I got from this committee asking for written evidence, I think had words to the effect that I shouldn't be comparing stories with other witnesses. I've tried to respect the processes of this committee.
I fully understand your position there, First Minister. The reason I'm labouring this point, and I dare say the reason Mr Fraser and Ms Baillie are labouring this point, is that if this is true, this may turn out to be one of the biggest failures of the complainants at the heart of this, that their name was passed to the emissaries of the man they were accusing. And it just feels like that you've just taken the word of the person who's accused and not investigated. I won't proceed any further on that matter.
Just,
of course.
I don't want anybody to think that I don't treat this seriously. But this, and I say again, you've said things there to me about Jeff's account that, certainly to the best of my recollection, I've not heard. So I've not seen Jeff's account. It is open to this committee to have Jeff and the other individual who were actually party to this discussion in front of them, at least privately. And you know, I can only say so much about a conversation I was not party to. What I do know is that Alex Salmond himself gave me or shared openly at the meeting on 2nd of April, the identity of at least one and possibly 2 of the complainers. And to the best of my recollection, did not give me any indication that day that he had got the identity of a complainer from somebody with the description that you're using.
Thank you. I'd like to move now to the leak to the Daily Record. I won't cover that in and of itself because I think Jackie Baillie's done that very well. But I find it curious that the day before the leak to the Daily Record, the government was about to press release the fact of the investigation and were only stopped by legal action from Mr Salmond. Was that press release prepared with your consent?
So the chronology of this is that I was written to by the Permanent Secretary. I can't recall whether the committee's got that letter. I don't see why it wouldn't have. On the 22nd of August, I think I've got the letter somewhere here, but I'll go through it from memory right now, telling me that the investigation had concluded, that certain things had been upheld, that a decision had been taken to refer, I think, 3 matters to the police. By the time the Permanent Secretary wrote to me, that referral had taken place. And that letter on the 22nd of August told me that there was further consideration about putting into the public domain some very limited information, and but that decision hadn't been taken. So it was not my press release. It was not a press release I was preparing. As I understand it, I think I understood it at the time, but as I certainly understand it now, the reason for that was that the government also had a requirement at that time to answer a freedom of information request. And the question was whether, well, I can't remember the exact phraseology of it, but would have required that information. On the day of the, if I get my dates right here, the 23rd of August, when I think the Permanent Secretary decided that a limited amount of information would be put in the public domain, that was notified to Alex Salmond. His lawyers threatened interdict action, and the government decided not to. The query from the Daily Record came in later. I understand the government made Alex Salmond's lawyers aware of the query from the Daily Record, and you know, it's not for me to say. Alex Salmond at that point clearly decided not to take action against the Daily Record. So that's my knowledge of the chronology of that.
That's very helpful, thank you. Very brief question on this. Were the complainers asked if they were happy for the press release to go, or that limited amount of public information to be released?
I wasn't, it wasn't me as the decision maker in this process. Now from memory, again, I'm going to check this. I think they had certainly been told that there was limited information going to go out. What I can't recall, and I would need to check, is whether they had been asked their opinion or just advised of it.
Two final short questions, if I may, Convener. It's odd, but the police had expressly advised against releasing information of this kind, considering it had been passed to Crown, or the report had been passed to Crown as well. Can you see that, taken together, these two things, the press release and then the leak, look like a determined attempt to splash this information in order to damage Alex Salmond, irrespective of what that might mean for the complainers?
So I think if you want to see it that way, you can certainly see it that way. And I should say, I'm now commenting on things that I know about, that I wasn't centrally involved in the decision-making around at the time. But I would go back to the fact that, as I understand it, what tipped the balance in favour of putting some limited information into the public domain was the freedom of information request that had to be answered. And that was the basis for that consideration. What I would say, and I've said it before, and I can't speak for anybody other than myself here, I did not want ever to be in a situation where I was standing in front of a camera talking about allegations of this nature against Alex Salmond. I had no desire for this to be in the public domain. I certainly would not have tried to illegitimately block it, because that would not have been appropriate. But, you know, I think when I think I did know that because of the threatened interdict, a planned press release couldn't go because there had been interdict action threatened. I recall that, feeling quite relieved about that, because it meant that I wasn't suddenly facing this thing coming into the public domain. I never wanted any of this to happen, and I certainly wouldn't have had any desire to see this forced into the public domain.
Forgive me, First Minister, I wasn't suggesting it was necessarily you that had the desire to push that information out there. My final question, you'll be glad to hear, Convener. Around this time, the report of the investigation was also passed by the Permanent Secretary to the Crown Agent against the wishes of the complainers at the heart of this. Was that the right thing to do?
I think on balance, yes, it was the right thing to do. It wasn't, so when the Permanent Secretary wrote to me on the 22nd of August, that referral, it wasn't just that the decision had been made, the referral had been made by that point. One of the things I've found myself doing, and I'll answer it specifically in relation to this, in terms of all of the charges that are being levelled at me or the government generally, is to almost pose the counterfactual. Had we done the opposite, by we, I'm just talking generically here, so had the Permanent Secretary sitting with allegations, complaints that she'd gone through a process and thought had substance to them, and on the face of it involved criminality, alleged criminality, not passed that to the police, and that had then later come out, I think the questions that would be getting posed would be just as serious, but from the opposite perspective.
In fact, that would have been criminality against people who have agency and the capacity to make decisions about what they want done with what's happened to them. And these women expressly said they didn't want a criminal involvement.
I think government has, and I've read some stuff, I don't I will have it in here, but I'm not going to start looking through it. I think ACAS guidance talks about, sometimes there is still a need to refer something to the police, even when people don't want that to happen. The Scottish Government's got a duty, and I use that in a kind of not a technical sense, although it maybe is true in a technical sense, if it thinks criminal acts have been committed to do something about that, I would think. I don't know how strongly the opposition was expressed by the two complainants, but I think these things often come down to judgment, and I think much of what we're discussing here today, and much of what we will discuss here today, the things we are being criticised for, I am being criticised for, perfectly legitimately. I understand why people are doing that, but had I done the opposite, I would also be getting criticised, and that's perhaps just a reflection of the invidious, almost impossible situation this placed a lot of people in.
Thank you, Convener.
Alasdair Allan.
Thank you, Convener. To build on some of the questions there, one of the questions asked there by Mr Cole-Hamilton, you've described the circumstances around the press release, and indeed Mr Salmond described to us in his view as remarkable the fact that the Permanent Secretary had planned to make a press statement on the 23rd of August announcing the outcome of the complaint against him. Did the Permanent Secretary or anyone else in the Government subsequently seek to give a formal explanation of that order of events and the reasons behind them? To you?
To me? The Permanent Secretary's letter to me, I can dig it out exactly if people want me to quote from it, indicated, this is the one on the 22nd of August, that the issue of issuing a press comment was still under consideration, and then the freedom of information. So that's been what I understood then, and what I've understood since, was that the reason for deciding on the balance of judgment to do that was that there was this outstanding freedom of information request that had to be answered. And I think it was asking the question, have complaints or concerns been raised about Alex Salmond's behaviour? So that was the judgment that was made. Again, I play the counterfactual. Were we sitting here, a couple of years on, and this had all come to light, that there had been a government investigation that nobody had known about, that it had upheld complaints against Alex Salmond and put in a drawer. Now, people can draw their own judgments on which course was right or wrong, but I bet my bottom dollar I'd probably be sitting here right now answering questions about why we thought it was appropriate to just keep it private. So these are really difficult situations, really difficult judgments. Did government, me, the rest of us get every single one of these judgments right? Possibly not, that's for others to judge, but I think at every step of the way there was a real effort made to get it right. Now, the other thing I've tried to do, and actually it's not that hard because of my past relationship with him, I've tried to see it from Alex Salmond's point of view. Given his position, given what he's gone through, subjectively, I'm not surprised he takes a different view on some of these key judgments. That's understandable, but it doesn't necessarily make him right and the government wrong. And that's just the fact of the matter.
If I can turn to one of the other issues in that case where Mr Salmond took a different view, speaking to us, and where you take a different view, it's a matter of record that Mr Salmond was of the view that you should intervene to advocate the use of arbitration in the complaints against him. I asked him about that last week, about whether arbitration for a public law matter related to sexual harassment in this case would not have been inappropriate. Now, that was something he refuted. Should the Scottish Government have looked at arbitration in your view, or do you continue to take the view that your government was right not to go down that line?
So, Alex Salmond wanted me to intervene on at 2 points on two issues. Firstly, before we got to the point of arbitration, he wanted me to intervene to effectively persuade the Permanent Secretary to agree to a process of mediation. Arbitrate, and that would have been mediation as I understood it, between him and the complainers. It was later that he started to seek a process of arbitration of the procedure. Now, I suppose the government considered, in terms of the process that was underway at the time, these things were considered. They came to the views that these weren't appropriate things. I think, if you want my view now, I think mediation, particularly as I understand it, the complainants didn't want that. In a situation like this, would not have been an appropriate thing to force into a process that didn't, in and of itself, allow for that. And then arbitration of a public procedure where the issues were very much kind of public law issues. I'm not an expert on this, but it's not immediately obvious to me that arbitration would have been the right thing to do that, or necessarily a quicker or cheaper or more effective way of dealing with these things. But these were things the government looked at in the course of the investigation. The issues for me are not so much whether I think mediation or arbitration should or should not have happened. The issue for me was it appropriate for me to intervene in the process to try to bring either of them about. And I don't think it was, given the nature of this process and my lack of role in it at that stage. And again, posing the counterfactual, had I done so, I think I would be facing serious criticism on that score as well. In fact, when this first came to light, I think from the questioning of me in the chamber, that's what people thought that they were about to sort of start to level at me. And I don't think the treatment of me would have been particularly favourable. I don't think anybody around this table would be sitting here patting me on the back today had I sought to intervene and influence the course of that procedure. Because the final point I would make, I'm not questioning that Alec thought that both mediation and arbitration might in their own terms have been appropriate. But I also had the strong impression that in terms of both of them, they were devices to stop these complaints coming to the point of decision. And therefore, had I intervened to try to bring them about, I would have felt that I was effectively colluding with him to try to thwart the direction and the natural course of an investigation. And I think that would have been a heinous, egregious breach of my position.
I appreciate the distinction you make, First Minister, between arbitration and mediation. It became clear last week that Mr Salmond does not believe that the original complaints under the procedure were so much made in bad faith. Rather, he seems to believe, or he indicated, that in his view, various people were trying to manufacture allegations against him after that point. He cites a variety of emails sent out to past and present members of staff, particularly to women around this time. He believes those, or he indicated to us that he thought they were a fishing exercise rather than offers of support. What's your understanding of all that and of all those communications?
Well, the ones that I know have been raised particularly are the ones sent by the SNP. So on two occasions, one at the time of Me Too, we developed, I think other parties were doing the same, we developed not a new procedure, but a different route for people to raise complaints, so an independent route. A lawyer was there that people could go to speak to if they didn't want to go through the more internal route. And we sent that out, I think, in an all-member email around about the end of October. And I think that also went to staff, or some communication around that went to staff. And then, secondly, after the situation with Alec had become public, again, communications went to, I think, all members and to members of staff, particular members of staff. That was a duty of care move at a time, you know, when you've got high-profile situations like this, I think most organisations should and are right to perform that duty of care role of just saying to people, not fishing exercise, but if you've got any concerns, here's how you go about raising them. I really struggle to see from an objective perspective, and I appreciate, and it's not a criticism, I appreciate Alec can't be objective in this, but from any objective perspective, I think that is not just a reasonable thing to do, but a perfectly appropriate thing for the SNP to have done. Beyond that, I really, it dismays me to hear suggestions that people were concocting or making up allegations. A number of women came forward, and they came forward of their own free will. Did they support each other along the way? Some of them evidently did. You know, did people in the SNP, people who work with Alex Salmond, talk to each other, support each other? Absolutely. To try to suggest that is something it's not, I think is seriously wrong. To this day, I don't know the identity of every single complainer in the criminal trial. Some of those whose identities I do know, I don't know them well. And to the best of my knowledge, they don't all know each other well. The idea that this was some concoction or plot is just not based in any semblance of fact or any semblance of credible evidence.
On the issue of the government's legal advice in the actual process, what role, can I ask, does external counsel, I should say...
Can I intervene here, Mr Allan? Would you mind if we left that till we get to the judicial review section, please? I think it would make our splitting up of our chronological decisions more sensible.
Okay, in that case, can I ask more generally about the evidence, as it were, behind your position? I asked Mr Salmond this question about the evidence that he could provide behind to back up his position. So Mr Salmond, for instance, has implied to us that there are many documents which have neither been able to be led in the criminal trial nor released to this committee, which back up his position on the claims he made in committee last week. Do you have a view on all of that and on why they have or haven't been released, or the conclusions he draws from these facts?
I think it's fair to say I do. I mean, firstly, I heard him say last week that, you know, the First Minister says I've got to produce evidence. You know, it's not for me to produce evidence. I've already gone through 2 court cases. I'm not suggesting and wasn't suggesting that Alex Salmond has to evidence his innocence of criminality. That was done in a court, and that's beyond question. But if you're going to pose the suggestion or put forward the suggestion that there is some kind of plot, or as I think he described it, concerted malicious campaign, I do think there is a need to evidence that, and I have not heard evidence of that. There has been references repeatedly to material that was handed over to his defence as part of the criminal trial. By definition, that is material that must have been seen by the police, by the Crown. I understand there were applications to have that material introduced into the criminal trial, and the court decided it was not relevant. I would just, I suppose, put forward the view that if this material showed what Mr Salmond wants us to believe it shows, then somebody in the police or the Crown or the court might have seen that too. The fact that they didn't, I think people should draw some conclusions from. In terms of the messages that have been quoted, yes, I have tried to find out, you know, where they're from, who they're to, you know, what the context is. And every single one that I've managed to get to a point where I can have a view myself, they are completely not the opposite of what he's trying to suggest. They're taken out of context, misrepresented, twisted. What they show, in terms of what I have seen, are people supporting each other, people talking to each other, a bit of gossip about what was going on. Remember, this was a massive thing for the SNP, particularly for people who had worked closely with them. And also, people cooperating with police inquiries. People, the SNP and individuals in the SNP were being asked to cooperate with police inquiries. And some of what's been misrepresented as trying to find or concoct evidence is actually people cooperating with the police at their request. So I have seen nothing that comes within a million miles of backing up that central assertion that Alec was making, that there was some kind of coordinated attempt for whatever motive, and the motive seems to be on shifting sands as well, the more I listen to it. I have seen nothing that comes within a million miles of demonstrating that.
Finally, in that case, Convener, if I can rewind a little, you alluded to this earlier on, but one of the first things we looked at as a committee was workplace culture. We obviously heard evidence on that from Sir Peter Housden, the former Permanent Secretary in the Scottish Government, who offered opinions about the workplace culture and offered comments about the former First Minister's place in it. Is there anything more you want to say about the issues that he raised and that you alluded to there?
No, look, the point I agreed with, I'm sure there was more than one, but the point I agreed with Alec on Friday is that this inquiry is not into him. This inquiry is into me and the government, and I accept that without reservation. I'd simply make the point it's impossible to to properly consider all these things without straying into, you know, the allegations that were made against him. I'm not here to, other than to rebut or explain my own actions, to cast aspersions on Alex Salmond. I'd dearly love to get to a point where I don't have to think about Alex Salmond's behaviour or alleged behaviour ever again, to be perfectly frank about it. He was a tough guy to work with. Personally, I didn't experience that very much, maybe the nature of our relationship. But he was a really tough guy to work with. Sometimes that was justified, sometimes it wasn't. And, you know, there would be times where I would, you know, tell him he'd gone over the score. And maybe, as I think I said to Andy Wightman earlier on, maybe those of us who'd worked with him for so long became a bit inured to that. So we didn't see it when it was, or didn't appreciate it from the perspective of people who weren't so inured to that. But, you know, these are reflections that are not particularly germane to the committee's questioning of me.
Thank you, Convener.
Jackie Baillie has a short supplementary directly related to one of Mr Allan's questions.
Indeed it is, and it's to the text and WhatsApp messages. Can I ask you about those that we discussed with Mr Salmond? I'm excluding those messages that the committee have seen that we regarded as not relevant to our inquiry, but I'm thinking of the messages that we have yet to see this afternoon. Messages between Peter Murrell, Chief Executive of the SNP, Sue Ruddock, Chief Operating Officer, and Ian McCann, Compliance Officer. Given that you're also the leader of the SNP, did you ask to see those messages?
I've made inquiries about the messages to satisfy myself. They're not my messages, but so, you know, if you take the ones between Sue and Peter, the ones that have been quoted, the ones that I have seen, you know, they are just not as presented. You know, Peter's given his own account of his messages. You know, it is, and you know, if and I don't know if the committee gets to see the full version of one of the messages that, you know, pressuring the police has been taken from, I think you see a very, very different impression from that. You know, these are messages from people who were cooperating with police inquiries, supporting each other. That message I've just spoken about, if I'm getting my dates right here, was the day after he'd been charged. I mean, just pause on this for a moment. This man that we had worked with, campaigned for, helped to get elected twice as First Minister, on the part of some of his people like me, considered him a really close personal friend, had just been charged with a number of serious sexual offences. I defy anybody in that position not to be really upset, a bit angry, and for that perhaps to come across in their communications. But the idea that that suggests some kind of plot or conspiracy is actually quite offensive, given the years of loyalty that the people being accused of that have shown to Alex Salmond. You know, he quoted 4 messages on Friday that I have taken steps to kind of make sure I could satisfy myself are not untoward. And, you know, they are just... One of them, as I understand it, because I've been, you know, told this by people whose messages they are, one of them I think the committee has seen as part of what it saw previously. You know, and others are just about people. You know, there was one where he said something like, where is it? Yeah, tell me the evidence I want, or I'll get it for them. What that is somebody who had made a complaint, who'd spent hours and hours and hours with the police. And
First Minister, can I stop you there,
okay,
please? Our committee is going to see some messages later on that we requested of the Crown Office, and I don't think it's appropriate for us to be taking a view on them before we've read them in context.
My apologies, I was trying to answer
a question.
I know. Suffice to say, these messages, and the committee will draw its own conclusions. I'm not saying I've seen all of the ones that the committee will see. I have no idea. But these are people who were upset, at times angry, talking to each other, supporting each other, and crucially, cooperating with police inquiries. And seen in context, I think any objective person will draw that conclusion, certainly based on what I've seen.
Well, the committee will draw its own conclusions.
Yeah, the convener is right to remind us of that, but I'm not asking about the messages and the content of them. I'm asking whether you've seen them and whether you're reassured by them.
So I don't know if I've seen all of the messages Alex Salmond is referring to, because I don't know all of the messages he's referring to. I have seen or I've had an account of the ones he has quoted, and yes, I am satisfied that they are not, as he is suggesting, in terms of the motive and what lies behind them, is anything like what he is suggesting.
Sorry to press you on this, but I'm asking, have you asked to see them all? As leader of the SNP, have you asked to see them all?
I don't know what all is, Ms Baillie.
Okay.
I don't know what all means in this context.
Fine, I'll leave it there. Thank you,
Okay.
Convener.
I have two more requests in this particular section on complaints handling. I have Margaret Mitchell and then Andy Wightman.
And it's now good afternoon, Mr. First Minister. Before I get to my substantive point, it would be good to clarify just some timescales here. We know Fairness to Work took 18 months to develop. This procedure took 3 months. Can you confirm when the claimants, the complainants, finally decided that they would officially complain?
If you give me, I can find that this is stuff I only know in the way you know, because I now, well, not quite in the way you know it, but this is stuff I am telling you with hindsight. So as I now understand it, the official complaints were made in the January, although there had been some informal contact in the latter part of the previous year.
Okay, thank you. And can you tell me when the procedure was published on the Scottish Government website?
It was published in February of 20... So I'm getting my years mixed up here, 2018 that would be. I can find the date, I want to say the 8th, but I'm not 100% sure that it's precisely the 8th, but February, and there's been an issue made of why did it take so long to publish it. We were also doing some work to review the Ministerial Code for the same reasons out of Me Too, and the decision had been taken to publish it all together.
Right. So when was the policy signed off?
The 20th of December.
That, you'll be aware, is being disputed by the First Minister and...
I am the First Minister.
By the former First Minister. Just in his last submission, so it's maybe something that...
what does he dispute? Does he dispute the date of the sign-off of the policy? I wasn't aware he did that.
It was 3 months in the development. It started in November, December, January, and then published immediately. It was signed off, which would be February. Yet the complainants, as you've just said, made their complaint in January before he is alleging the complaints procedure was signed off.
Again, I'm in this context, it might feel a bit unusual here. I'm jumping in maybe wrongly to defend the former First Minister. I'm not sure. So he certainly disputes a lot of this, but I wasn't aware, and maybe I'm wrong, that he disputes it was signed off on the 20th of December. He obviously has an issue about the fact that it wasn't published straight away, and therefore why were complainants aware of it. But it was signed off on the 20th of December. There were no changes made to it after that, and it was published in February. Was that ideal? No, it wasn't, but the reason for that is that there was other work, related work underway. And of course, as we know, that one of the issues around the judicial review is that one of the concerns here was that it was in operation before it had been published in the way that you're talking about.
Can you tell us when the complainants first came forward?
I can find these dates because these are dates that I only became aware of afterwards, but I think they came, one of them, I think they were around November 2017 in terms of concerns first being raised, but then the formal complaints were in January 2018.
Yeah, I merely say there's a discrepancy then about how long it took to develop this process from beginning to end. But
I don't understand what you say the discrepancy
well, it was a
is.
3 months in the making. So if they only came forward in November, December, that would take you to the end of January before the procedure was signed off.
I really am not sure I'm following. The procedure was in place from the 20th of December. It wasn't published until February, but the procedure was in place and clearly being used. The dates that the complaints came forward is a separate, I mean, I know very related, but it's a separate issue. The procedure was signed off on the 20th of December. I know that because I did it.
Right, but the complaints only came forward in November. What happened in October? If it's a 3-month period from beginning to
So,
end.
Convener, with my apologies, I am not
I'm just
following
going to
this line
leave
of
that
questioning.
there. All I'm going to leave hanging in there, and others can look at it, and we can go back and check things.
Given the
3 months
series
policy, complainants came forward in November.
I don't understand the
No,
3-month policy.
Hold on, First Minister, and please, Margaret, could you go to the beginning of your query again?
Yes.
Because I think
When
it is
did the work
confusing.
start on developing the process?
The Cabinet commissioned it on the 31st, commissioned a review on the 31st of October. I think you've heard evidence from James Hind that the first draft of the policy which he was involved in was the 7th of November. So the work on the procedure started at that early November stage and concluded with the procedure being signed off on the 20th of December. The dates of the complaints are not, are separate from the development of the procedure. I know the two things are obviously in practice connected, but the procedure was developed and signed off in that timescale and in a parallel track, the emergence of complaints.
Okay, I'm going to leave that there because I don't think we're going to get too much further with that, First Minister.
I'm not sure I'm going to get much further with it, that's for sure.
And turn now to the issue that Alex Hamilton raised, and that's the fact that we know the complainants did not want to report their complaints to the police. But it was on the basis of the IO report and the Permanent Secretary's final decision this was done. We have a submission from Police Scotland came in January, and it makes clear that during the handling process, Scottish Government's officials made contact with the police. The initial contact was on 5th of December via email. On the 6th of December 2017, there was an in-person meeting. And between the 30th of January 2018 and the 3rd of August 2018, there were another 6 meetings. The purpose was to seek advice on the Scottish Government approach to the sexual harassment procedures and to the Scottish Government's obligation in response to allegations. Now, Police Scotland tell us this, and please bear with me because it is very important. Police Scotland provided advice at the meeting of the 6th on December 2017, advising that where criminality was suspected and individuals, that's complainants, should be directed to support and advocacy services to enable them, that's complainants, to make informed decisions about whether or not to report matters to the police. So it's very firmly in these individuals' hands. And then it says, this advice was reiterated on several occasions throughout an ongoing contact between 2017 and August 2018. A number of hypothetical questions were posed during email and telephone contact around the criminal justice process. Police Scotland advised without specifics, no appropriate response could be given and no assessment of risk could be made. And it was further emphasised that individuals should be directed to the relevant support services. As it appeared, the hypothetical questions were predicated on a set of circumstances and the Scottish Government responds to that circumstances rather than a generic procedure. It was highlighted that Scottish Government staff were not trained to undertake such investigations or to engage with victims. Despite this, First Minister, the Scottish Government officials continued with this investigation. Why?
Look, and I know that you will find this answer unsatisfactory, and I understand that. I can't answer that question directly because I wasn't involved in the handling of the investigation. I've read the letter from Police Scotland. I wasn't aware at the time of all of those contacts with the police, and I'm not aware of the detail of them. You know, clearly there is aspects to all of this that the Scottish Government needs to consider, and you know, this committee, I hope, will be part of that process of consideration. I'm trying today, the convener, I suspect, thinks I'm taking too long to do it sometimes. I'm trying to be as open with the committee as I can, but there is a limit to the degree to which I can comment on things that I just wasn't party to and at the time didn't have knowledge, because that is asking me to get inside other people's heads, which is not always a good idea, but to second guess decisions other people were taking at the time. And I will try to be as helpful in that as I can, but there are limits to my ability to do that.
So is it your position, First Minister, that you knew nothing about this police advice and that Scottish Government officials had been told that the staff were not trained to undertake such investigations or to engage with victims? Was that kept from you by these civil servants, these
remember,
Scottish Government officials? And if so, who were they?
I'm mindful of the convener's stricture earlier on, which I've probably breached in a number of ways about naming civil servants. As it happens, you know, we can provide as much information on that as you wish. Look, I was not aware at the time of these interactions with the police and the detail and the content of these interactions with the police. This is an investigation that I had no role in. I wasn't involved in the handling of the investigation. Now, you know, you may well be raising issues that we have to, and this committee may also want to reflect on these issues. I'm not suggesting otherwise. I'm simply saying, if your question was, why did a civil servant, having been told X by the police, decide to do Y? And I cannot today sit here and answer that question because I don't know the thought processes and the decision-making that lay behind that.
Can I ask you, knowing what I've just read out, was it appropriate for the Scottish Government officials to go ahead and carry out this investigation?
I mean, that is a matter the committee will want to have its own say on. I think it was appropriate. In fact, I think to not have done this would have been inappropriate when complaints came forward that they were taken seriously and investigated. I now know, and we all now know, that in the course of that investigation, those conducting it got things wrong. And what we particularly know is the appointment of the investigating officer and contact that the investigating officer had, and that was the focus of the concession of the judicial review. So I am not sitting here saying that there was nothing else that the civil service got wrong in the conduct of that investigation. That's partly what this committee is here to say. But I cannot equally sit here definitively right now and say any particular action that any particular civil servant took was inappropriate. The context of this was a government trying, in the light of Me Too, everything we've been through already, to properly investigate complaints that had come forward. We know it made a mistake, and this committee may decide it made more mistakes than that. But I cannot sit here on things that I was not involved in at the time and second guess the reasons why every single action and decision was taken.
First Minister, they ignored the fact they weren't trained and they shouldn't have been dealing with victims' complaints. That advice was absolutely crystal clear. They ignored that. You said they made mistakes. Well, they weren't trained to do it. And apparently you knew nothing about this. And more than that, the complainer's right to decide for themselves whether they would take this, their complaints forward. Having spoken to the people who were trained to speak to them, that support and advocacy service was taken completely out of their hands. Do you understand why you wouldn't have had this dilemma should they report to the police, despite them not wanting to? Because it was quite clear The Scottish Government officials should never have been anywhere near this investigation. At that point, it should have ceased, and the complainers should be referred to support and advocacy, and the choice would therefore be with them.
Can I intervene here? Because I think for the benefit of clarity, there's two different things here. That,
Convener, would you let the First Minister and then maybe give some clarity?
I would like some clarity myself, thank you. I think what we're talking about here is two different things. I think the first thing was about the development of the policy.
Yes.
Yes, the first thing was about the development of the policy and advice that was asked for and given by the police about the development of the policy, and then the implementation of that policy, which was about whether there should be independent trained people involved in that in such serious cases. And I think, Deputy Convener, you then got on to whether it was appropriate for the matter, once investigated, to be passed on to the police.
I appreciate that, Convener.
Yes.
But you're just wrong. It was 2000.
Well, okay. Can I
tell you why? These approaches were made
Deputy
in
Convener,
2000.
Deputy Convener.
This is a crucially important
Deputy
point,
Convener,
and you're shutting it down.
No, I'm not
Convener.
shutting it down. I'm trying to get some clarity for myself. So if you let me finish, you can come back and clarify. What I picked up beyond the development of the policy was that there was an issue about whether it was appropriate for the civil service, therefore, to have passed the complaints on to the police for a police investigation. Yeah. Right. Well, if that wasn't the case and there was no confusion in your mind, Deputy Convener, about that, can I then supplement your question with that as well while we're on the subject of the police?
I appreciate you trying to be helpful, but it confuses the issue. The issue was the investigation officer's role. And when they approached the police, these Scottish Government officials, it was to look at how the procedure would be developed. And then they gave some hypothetical questions. And from that, the police began to suspect that this wasn't just a procedure, they had something in mind. And they were told quite clearly that they weren't trained and they shouldn't be talking to the complainants about that if criminality was suspected. And therefore, they should have gone to advocacy services, and the complainants should have had the ability to complain for themselves. Now, you appear to be totally unaware of that, First Minister. Does that mean that the officials didn't report this to you?
No, they didn't report this to me because they were conducting an investigation that I was not meant to be party to. I have to confess, and I take responsibility for this myself, I am a little bit confused about what exactly you are trying to get from me here, so I will do my best, and if I'm getting it wrong, I know you'll jump in and tell me. There was advice taken by the police, as I understand it, both on the development of the policy, and then they were going to the police, I think, taking advice that perhaps was more about the application of that policy. Was that always right and appropriate? Did they always follow the right advice there? That's what I cannot sit here and say categorically, because and that's something that the committee is looking at. What I do know is that these complainants made complaints to the Scottish Government. So I think I would push back on the idea that the Scottish Government should not have tried in any way to investigate them. There is perhaps a question about the appropriate moment and was the right moment chosen to refer to the police, and that is something that the committee may want to say something about. There is then the question of should that referral to the police have happened, given that, and as I said to I think Alex Hamilton, I don't know how strong the views on this were on the part of the complainants, but that they didn't want that. Now, I do think on some occasions there are duties on public authorities to report suspected criminality, even if others don't want them to do that. But on what the complainers wanted, what might have been a better way for the complainers, you know, I don't know if the committee has taken views, I know it would have to be done privately, but from complainers themselves, because there was then a police inquiry where presumably people had to decide the extent to which they wanted to make complaints to the police that would be investigated in that way. I can't speak for complainers, and I do think, again, not a criticism of the committee, I think one of the genuine worries I have here is the extent to which this whole process is kind of sidelined and silenced the voices of complainers, and I know that's not what anybody in this committee has wanted or tried to do. So I keep saying it's not for me to tell you how to do your work, and it's certainly not. But if you want to know what the complainers thought, then perhaps trying to speak to them would be a better way than trying to get me to second guess their views and then what that should have meant for how the government did things.
Let me just reiterate that the first approach to the police was before the process had been signed out. It was the handling. And that was in the beginning of December, 5th and 6th December, with various meetings thereafter. And it was made clear at that point that it wouldn't be appropriate for the investigation officer that carried out the investigation and for the people who spoke to the complainants to carry out that role, that at that point, beginning of December, if they knew about something, if they had concerns, they should have been, the complainers should have been referred to the appropriate people who were trained and could properly give them the advice to decide if they wanted to go forward with the complaints. And while this whole process is about the complainers, they were denied that opportunity, and that decision was taken out of their hands because of the Scottish Government's handling of the complaint. And that goes to the very essence, First Minister, of our remit, and it goes to what we have to look at to make sure that this never ever happens again, because as things stand, there's absolutely no possibility, I think, in everyone's mind, that anyone would want to come forward with a complaint as a result of how this was handled.
So, in many ways, I don't disagree with a lot of what you said there, and people can take this in whatever way they want. I hope the committee doesn't take it as a criticism, because it's not intended in that way. But the fact that everything you've just said in your last few sentences there is true, it leads me to think it is quite extraordinary that the complainers or complainers' voices haven't been not heard publicly, but heard more strongly in the process of this inquiry. That's a personal opinion, and I'm just going to stop it there. I think the most important people in all of this are not me, obviously in terms of parliamentary scrutiny, of course it is, not Alex Salmond, it is complainers who were let down by the mistakes that the government made. I'm happy to, if the committee reflecting on the official report of this thinks there's more I can provide here, I'm happy to supplement in writing. I think, and I don't have the police letter in front of me, which is why I'm acting on memory here. I think some of what you quoted to me there was police advice given effectively in the abstract about a policy and what to do in particular hypothetical situations. The issue then of when you had a real situation, did the civil servants follow that advice or not, is a separate issue. And it's an issue the committee may well have views on. So I think I've probably gone as far as I am able to, both in my understanding of the questions and my understanding of what lies behind them. But I'm happy if it would be helpful to the committee to try to follow up in more detail in writing.
I think that would be very helpful, and to know exactly who met with police and to know who ignored this. And just to point out again, First Minister, the police formed the view that the hypothetical questions were predicated on a set of circumstances rather than a generic procedure. And it was made quite clear to them in these circumstances, these people carrying out this development and speaking with the complainers and ignoring them wishes, that they were not trained to do so and they should have been referred to advocacy services.
I am not sitting here arguing against what you're quoting to me there. I'm simply saying that I think this needs proper consideration of which this committee is part in terms of the advice in the abstract and the hypothetical, and whether that advice was properly applied when the hypothetical became actual complaints. If the committee wants to put in writing some particular points of clarity or further information, I will do my best to answer that.
That would be very much appreciated, because it's absolutely essential to make sure this never, ever happens, and this kind of advice is never, ever ignored again by Scottish Government officials. And I'm sure, First Minister, you wouldn't want to be party to that happening within a government that you lead.
You will get nobody agreeing with you more strongly than me that I never want a situation like this to happen again. And I would like to think complaints like this wouldn't have to come forward again, but that we don't make mistakes here. But equally, I don't want to have a situation where, because of the experience of this, there is a reluctance on the part of government to properly investigate complaints, or a reluctance on the part of complainers to come forward. And that's going to be a difficult thing to make sure we get right overall. And I remain hopeful that this committee will be part of the process. But I do think complainers' voices themselves matter in all of this as well.
You just seem to have missed a crucial point. It's not for the government
Ms Mitchell,
to
we've spent half an hour
investigate
on
the
one
complainant,
question.
to
So
take them on board and then refer them to the people who are qualified and trained to deal with the complainers.
Can you have the last
Two
very
different
short
things.
word on this, please, First Minister, and then we really
I'm not
must
sure.
move on.
So I think you can raise a question about whether the complaint should have been referred to the police earlier in the process. I'm not sure about just handing them over for advocacy and effectively not doing the complaint. I don't know whether I think that would have been right in this situation, but I'm not sure I'm helping the situation here. I'm not sure I'm helping bring clarity to this situation. Where I absolutely agree is that the centrality of complainers' wishes and voices can't be ignored, and the determination to learn from the mistakes that were made here is absolute on my part and the Scottish Government's part. But, you know, there is always a different path you can take on everything. And I suspect on this, had we taken the different path on all sorts of aspects of this, it might not have resulted in us not sitting here. We'd just be sitting here and the questions would be coming from a different perspective.
I think any complainers would welcome knowing that if they did come forward, they would be dealt with properly and referred to the proper services in
As I
future.
say,
That would give them, I think,
Please,
a
now,
lot of comfort.
can I just intervene here? Can I say, Ms Mitchell, that I asked the First Minister to have the last word on that. We've been half an hour on one question, and I think we really must move on now. So, before Mr Wightman winds up for us in this particular section, I have very quick supplementaries, and please make them very quick. Maureen Watt and Stuart McMillan. Maureen Watt.
Thank you, Convener. I mean, First Minister, a lot of this has been covered in earlier evidence sessions with senior civil servants, but the ACAS guidance on sexual harassment states that if complainers do not want to tell the police, you should still encourage them to do so. You might still need to report it, but should always tell the person affected if you're going to do this. Now, I have, in my earlier questioning of civil servants, been quite keen to find out the appropriateness and the qualifications of many of those involved in HR procedures. And it took a long time to tease out those who were qualified and those who weren't. But I think in this situation, the Scottish Government seemed to have been acting within clear employment guidance in reporting this matter to the police. So I'm not asking you to tell us now, but do you think this is a paragraph in the procedure? And I think in our reporting, in our report, I would like to make a point about asking whether enough qualified HR specialists are involved in the Scottish Government.
I think that's a fair question. I can't answer it today in terms of how many civil servants in the Scottish Government are HR qualified and versus how many should be, but I think it is a perfectly fair and legitimate question. The ACAS guidance, I think, that you've quoted there was what I was searching for a wee while ago, and it is there and clear. I think the procedure itself talks about the possibility of complaints being referred to the police. You know, I appreciate the view that because the complainers said it was a preference that that shouldn't happen, that it shouldn't have happened equally, I take the view that there is, as the ACAS guidance sets out, a wider interest that has to be considered.
Okay, kindly, Mr McMillan has said that his question was already answered. So, Andy Wightman, please.
Thanks, Convener. Just loath to continue the previous conversation, but the letter from the evidence from Police Scotland, which I have in front of me, is to the effect that they provided advice at the meeting on the 6th December, advising that where criminality was suspected, individuals should be directed, and then going on to say that Scottish Government staff were not trained to undertake such investigations. On my reading, that's the police saying that Scottish Government staff are not trained to undertake investigations into potential criminality, and I think you would probably agree that that is not their job. And a reasonable explanation might be that Scottish Government staff did not believe at the outset of the complaints that there was in fact potential criminality that only arose later. So I think it's important for the record to set out what the police's concerns were correctly. So just to conclude on the handling of complaints, I think I'm the last word on the handling of complaints stream. In your written evidence to the committee at page 8, you said in relationship to the meeting on the 2nd of April, I quote, "I made clear to him," that's Alex Salmond, "that I had no role in the process and would not seek to intervene in it." Mr Salmond, in his evidence from last week, said, and I quote, "There's no doubt that people at the meeting, Mr Aberdeen and Mr Hamilton, were there. Certainly Mr Hamilton was there when Nicola said that, and she said it to me in a private meeting as well, that she was anxious to assist." It's from the official record on Friday. In a written evidence submitted yesterday, Duncan Hamilton QC states that his recollection was that, and I quote, "We discussed mediation. My clear recollection is that her words were, if it comes to it, I will intervene." So your own written evidence says that you made clear to Mr Salmond you had no role and would not seek to intervene. Mr Hamilton's recollection is that your words were, if it comes to, I will intervene. Can you explain that contradiction?
I certainly will attempt to. I believe I did make it clear that I would not intervene. I also know, and I'll maybe expand on this in a minute, that I was perhaps trying to, how would I best put this, let a long-standing friend and colleague down gently, and maybe I did it too gently, and he left with an impression that I did not intend to give him. I think I was clear, and certainly intended to be clear. If you look at the statements that are being made, and I don't recall the particular words, but I'm not quibbling with the sentiments behind them necessarily, because I can't recall enough to do that. But the things that if it comes to it, I'll intervene. If it comes to what, I saw, I think in a written submission from Mr Salmond, him saying something like, "I'll intervene if at an appropriate time." He said on Friday that I said things like, the Permanent Secretary has to come to me first. In the procedure, the Permanent Secretary, it only tells me at the end. So all of that says to me that I was possibly couching, I'm not intervening, in terms that were, given the relationship between us, not as blunt as they maybe should be. I had no intention of intervening, and crucially, I did not intervene in the process, and that is the case. During this discussion on the 2nd of April, to be blunt about it, my head was spinning. I was experiencing a maelstrom of emotions. I'd been told something pretty shocking by Alex Salmond, and there were there were a number of things in my head. A very strong instinctive view that I couldn't and shouldn't intervene. The kind of dealing with a friend, and perhaps that leads to some of what I was saying. And also, there was things going through my head. I was thinking about, which we'll come on to later on, the kind of ministerial code, should I be reporting any aspect of this? So that's the kind of, these discussions, and everybody knows this, these discussions don't take place in a kind of antiseptic, sterile, devoid of human emotion environments. But I did not did not intend to intervene, and I did not intervene. And while I know it's more complex than this, I think in terms of his anger towards me, I think that is the root of it with Mr Salmond.
Okay, thanks. And my final question relates to the all of this becoming very public on August the 23rd. In the review of the criminal investigation teams looking at the leak in the Information Commissioner's Office, in that review report at 4.2, it says that the leak came a few hours after the Scottish Government had notified their intention to publish a press release, and very shortly after Levy and McRae had given notice of their intention to apply for an interim interdict. The effect of the leak was to defeat the court action because the information was by then in the public domain. And the Information Commissioner Review Team also go on to say at 4.3, I've also considered the statement of Detective Chief Superintendent redacted, helpfully provided by Levy and McRae. Now we're aiming to get a copy of this statement. I'm not sure if we'll be successful or not, but nevertheless, the statement confirms that a meeting on the 21st of August 2018, which we talked about yesterday with the Crown Agent, the Chief Constable, the Detective Chief Superintendent and the Crown Agent were present. The police were offered a copy of the internal misconduct investigation report but refused to take it. Furthermore, at that meeting, Detective Chief Superintendent voiced concerns about the Scottish Government making a public statement about the outcome of their investigations. Were you aware of the concerns that had been voiced by the Detective Chief Superintendent at that meeting?
Not at the time, no. As I think I said earlier on, I was told by the Permanent Secretary, by the time I was told by the Permanent Secretary about referral to the police, the referral had already happened. And I didn't know at that time what the police's reaction to it was, or what the police had said, or what they were doing.
So you were never told even after that event what the just a minute. You were never told after the event what the concerns had been that the Detective Chief Superintendent had raised about making a public statement.
So, by after the event, do you mean in the days around that?
No, I mean up till now.
Well, I've
do you have
heard,
any knowledge? Do you have any knowledge of what those concerns were?
I know what is now being said. I've read what you have said. I don't think, from the best of my recollection, I don't think I was aware of that at the time. And I've not had detailed discussions about what the views of the police were in that respect.
Okay, well, we don't know what the concerns were at this meeting. We don't
So
know the concerns.
In detail, I don't know either.
Okay, that's my only question, really. We don't know the concerns that were expressed at that meeting. We're going to try and find out, but you don't know what those concerns were either. Is that's the case?
I think I've assumed, I'm trying to kind of make sure here I'm being, I kind of assume that they didn't want public release because it may get in the way of an investigation or whatever.
That's just a presumption, though. You don't know.
I think that's just a presumption. I'm not, I don't think I can be 100% sure that that's never been said to me, but I don't think that has been said to me. I think what I've just said there is in the realms of presumption rather than actual knowledge.
Okay, so you don't know and we don't know what those concerns, we don't know and you don't know what the concerns of the Detective Chief Superintendent voiced at that meeting were. At this moment, we don't know.
I don't think I know beyond presumption.
Okay. We'll try and find out. Thank you, Convener.
So nobody in this room knows anything about that. We'll now move on to the judicial review section, and Murdo Fraser.
Thank you, Convener. If you'll indulge me, I have a number of questions in this area. Can I start, First Minister, and ask you, what was your role in relation to the judicial review? To what extent was there ministerial oversight of decisions that were being taken?
So my formal role, I was named as an interested party in the petition. It was a petition against Scottish ministers, of which I am one, although it's, as you know, it's a collective designation. So I was involved in discussions about prospects of success and the changing sort of fortunes of the changing perceptions of those prospects of success as we went through. My involvement was greater at particular junctures. It wasn't something I was being briefed about or talking about every single day. It wasn't something. So just, I remember having discussions with SGLD, the Scottish Government Legal Department, around the time the petition was going through the process of ultimately being served in the Scottish Government. Initial views on prospects of success. I knew that there were discussions in, I think, early September into mid-September about preliminary issues that I was kind of aware of the views that were being taken. By preliminary issues, I mean, were we going to oppose permission to proceed? Things like time bar, were there any parts of this that we considered time barred? There was a preliminary issue about the designation, whether it should have been against the Permanent Secretary or just Scottish ministers, and the issue which I know the committee heard about from Mr Salmond about whether there was a case for assisting at that stage because of the criminal procedure or whether reporting restrictions. So I was aware of all of that in the early days. I then saw the note, which you have now seen, of prospects, which I think was late September, and saw initial pleadings, the initial government answers to the pleadings. So it was that kind of, I've been, as a minister, I've had, not lots, I hasten to add, but there's been some big high-profile judicial reviews against the Scottish Government that in my so minimum pricing, for example, being one of them. It was not an unusual degree of involvement or oversight. I mean, obviously, given who was taking the Scottish Government to court, made it slightly unusual. And then, I suppose, the next period where I would have been particularly aware of the detail of what was going on was around that end of October point. And then, clearly, I'm not saying there was nothing in between there, clearly the next key point would have been into December and ultimately the period where we decided to concede.
Okay, thank you. Well, that's helpful. I may want to explore some of the detail with you, if I can, but it sounds like you were quite well briefed all the way through the process. And can I ask you...
myself up for a fall here.
Can I ask you, your Chief of Staff was also involved, I understand, and attended a number of meetings, presumably to represent you and to feed back information to you.
I think she, and again, if I'm getting the detail of this wrong, I will stand corrected. I think she attended 3 meetings with Council, would have seen the stuff that was coming across my desk. That, again, is not unusual. I mean, you'll understand this, Mr Fraser. I'm a lawyer by background. There is a natural kind of interest in some of this stuff that goes beyond the sort of ministerial interest. It can be a bit weird, but that's it. So she was involved to the extent that she will be involved in a lot of things to make sure she's hearing anything that I need to be aware of and representing my interests. I was named on the petition, so that's not unusual. But she didn't have, an involvement that was any way unusual for a Chief of Staff.
Thank you. I'd like to take you through some of the legal advice that we obtained. Now, I think it's fair to say you'll recognise the committee's frustration. We've been trying to get hold of the legal advice for months. There have been 2 votes in Parliament. The government has not acceded to, and it's only with a threat of a vote of no confidence in the Deputy First Minister that finally do we see some aspects of the legal advice. We don't know for sure if what we've seen so far is the entirety of the legal advice, but it's all we have to go on for now. And perhaps you can tell us if there are parts that are missing from what we've seen. You referred earlier in questions, in response to questions that were asked by Margaret Mitchell and by Alasdair Allan about the note on prospects that was prepared by external counsel on the 27th of September. And you said, if I heard you rightly, you said that Council were confident, that was the term you used, I think, Council were confident about the case the Scottish Government had. I'm just having a look at the joint note by Senior and Junior Counsel by Roddy Dunlop, QC, and Christine O'Neill, and they say this at paragraph 6. We think there is a real risk that the court may be persuaded by the petitioner's case in respect of the ground of challenge based on procedural unfairness. And they go on to say, we consider the defence to be perfectly stateable. However, it would be wrong to pretend we do not see vulnerability in this regard. I wouldn't categorise that as confident. I would categorise that as a nervous judgment on the prospects.
So I wouldn't, in any kind of proper legal sense, and other people may take a different view of this. I don't think, and I've not gone back and checked all of this, so it may not be 100% accurate, but I don't think in all of the legal action, judicial review action that I have had ministerial involvement in, oversight of, during my years in government, I don't think I've ever seen an opinion that says 100% this is a cast iron case, there is no risk of losing this. You get the risks ranked in order. And actually, this note of prospects would be at the more optimistic end of some that I've seen. It highlights what they consider to be the greatest vulnerability. It turned out not to be the greatest vulnerability, but says we should stress that we do see an answer to this point. And that is actually the kind of thing in a legal opinion that does give you confidence if you're having a potential vulnerability pointed out. In fact, maybe I mentioned it a moment ago, and I've not gone back and looked at all of the opinion and all the legal advice on minimum pricing, so I am speaking from recollection here. But in the early days of minimum pricing, and it's a subject I cared deeply about, was very associated with, losing it in court would have been, posed great questions for me, as well as being really regrettable from a public health policy perspective. But in the early days of minimum pricing, I think if you were to apply anything like the test you're applying to this note of prospects, we would never have done it, because particularly in those early days, the view on our prospects of success were actually not that confident. But we took a view that this was an important public health policy. We thought we could argue it, and therefore it was worth doing because of the importance of it. And that's just the nature of this. And so in the context of all the legal opinions I've seen in different court cases, that actually is probably at the more optimistic end of the spectrum.
Okay. I'm not going to argue the toss with you on that, because to be fair, the Council's opinion says there's a stateable case. So I think it was reasonable for the Scottish Government to defend what was a stateable case. Let's jump to the 31st of October, because we have nothing in between that and the 31st of October. Now, on the 31st of October, there's an urgent note by Senior Counsel, Roddy Dunlop, and this has emerged because what's happened is it's been disclosed at that point that Judith McKinnon was the investigating officer, and there had been this issue of prior involvement identified at that point. And if you read paragraphs 9 and 10 of that opinion, Senior Counsel is clear this presents a very real problem indeed, he says, and he goes on to say in paragraph 10, it would be wrong for me to suggest that this revelation is anything other than an extremely concerning one. He goes on to say, paragraph 13, he is so concerned by this, he is sufficiently concerned by this, he's had to contact the Lord Advocate to express his concern as to the potential repercussions for the wider case. And then at paragraph 14, there is discussion then of the choice that needs to be made as to whether the case can continue, or indeed whether the petition should be conceded at that particular point. So is it fair to say at the 31st of October the case is in real trouble?
No, I don't think I would use that phrase. Other people might use that phrase. Again, this turned out to be more unusual and much more problematic than we realised at this stage. But again, in my experience, I can only speak from my experience, it is not unheard of during a process of litigation to have lawyers say there's issues cropped up that cause them real concern. That is not unheard of and unusual. This note, it says all the things you say, but it is clearly also considering the options and identifying further work that has to be done. After that opinion was submitted by Roddy Dunlop, there was a consultation with Council, I think 2 days later. I wasn't personally at that. And as a result of those discussions, and at that point the discussion was round the interpretation of Section 10 of the procedure and the differing interpretations that we thought that was open to. And the conclusion out of that was that it was a point, not that it wasn't a point we should be concerned about, and not that it wasn't a point of vulnerability, and certainly not that it wasn't a point that weakened our prospects of success, but that it was a point that was arguable and defensible, and that the government thought that argument could be made, and therefore the decision was taken to continue. And actually, right up until, I think, the 11th of December, and I think you've got this as well, views of the law officers was that across the petition, including on the issue of the appointment of the investigating officer, there was a stateable case and arguments that could be made. So I know we're seeing this in the context of a judicial review that's very high profile, very sensitive, that obviously has turned out to be incredibly so. But in terms of the process of litigation, this kind of thing in general is not, in my experience, hugely unusual, that problems are identified and assessments are made of whether they are fatal problems or problems that can be overcome. And there was, and you heard this from the Lord Advocate, right up until the point where it became unstatable, there were wider issues that we were weighing up. I mean, firstly, you have to be certain that you've got a statable case, and you know the degree of confidence that was there that the argument could be put. But there was a wider interest, and I think it was a legitimate interest. There were 8 grounds of challenge that had been made to the procedure and to its application, and therefore the government wanted, if possible, to hear from a court whether it thought those challenges were well-founded or not, so that we could have confidence, hopefully, that whatever, you know, might have happened in the Alex Salmond case, or whatever turned out to have happened there, we had a procedure that was lawfully based and sound. So that was the wider legitimate interest the government had in all of this.
Okay, thank you for that. I mean, it is a pity. We did have the Lord Advocate in front of the committee yesterday, and it's a pity we could not put these questions to him because we did not have sight of the legal advice until 6 o'clock last night. We then have a lacuna in the information provided to us because it jumps from the 31st of October to the 6th of December. Now, there must have been more consultations, notes and meetings held during that period. Are these going to be made available to us?
I am happy to look at what more is able to be made available or what more is there to be made available. But my understanding and recollection of that period from the end of October through to the beginning of December is it was a process of adjustment of pleadings going on in both directions. I think, I don't have the exact date in front of me, I think at some point over that period, Alex Salmond's lawyers introduced a new ground of challenge based on this, and that then triggered a review based on that led to the early December note. So to say it's a lacuna, I mean, I wasn't a litigation lawyer, so I don't know this from the perspective of a lawyer, but these periods in litigation where there's adjustment of pleadings, Andy Wightman probably knows more about this than I do, is not, again, it's part of the litigation process.
Okay, we know you attended a meeting on the 13th of November with Council. Can you tell us who was at that meeting and what was discussed?
I was clearly at it. Senior and Junior Council were at it. From memory, the Permanent Secretary was at it. Liz Lloyd, my Chief of Staff, was at it. I think SGLD was represented. That was part of, I requested that meeting, and actually that was kind of part of what I think was a proper thing I was doing, was kind of testing myself whether, as a result of what had come to light and as a result of the 31st of October position, we actually did still have a statable case, and that's why I requested that meeting, and I came out of that meeting satisfied that we had a statable case, that we thought not just in some theoretical abstract way, but based on actual consideration of what the government had intended around Section 10, that we could argue the interpretation that we thought should be attached to it. Of course, what happened later in December was things emerged, not about the interpretation of Section 10 per se, but about the extent of the actual contact between the IO and the complainers that changed that judgment. And also, to be fair, gave rise to suggestions that the government had not been as open about this as it should have been, which was not intentional, but gave that impression.
Okay, so a decision was a decision taken at that meeting to proceed with the case, and were you party to that decision? I don't think that was a decision meeting. There had never been any question. There had never been a point at which the decision had been taken not to proceed, or we got to that point. This was part of a process of me saying, and this maybe is given the high profile of this. Would I normally meet with counsel in a judicial review? Probably not. And it was just basically me getting an assurance that for all, because this note, the 31st of October note, which actually when you read it is not as it has been presented by some in this, but you know, it kind of raises concerns. So I just wanted to make sure we weren't in some way prolonging a judicial review that was
was dead in the water, and I was satisfied out of that meeting that that wasn't the case, that we had a stateable case and were confident that we could continue to put those arguments.
Okay, just to quote you again from paragraph 14 of Roddy Dunlop's opinion of the 31st of October, Halloween as it turned out, he says this: depending on the information available on Friday, a swift decision is going to have to be taken whether the issue is disclosed and any argument based thereon then resisted, or B, the issue is disclosed and the petition then conceded as a result thereof. So who took that decision?
I think the consensus that emerged, I wasn't at that meeting, I think one of the law officers, we're not meant to usually say this, obviously, but we're in a different position with legal advice. I think the Solicitor General was present at that meeting, and the consensus out of that meeting was that there was a case that continued to be stateable, and that there was a perfectly credible and arguable interpretation that could be on Section 10.
Thank you. We jump to the 6th of December, which is the next date for which we have documentation for. On the 6th of December, again, the situation has deteriorated to an even more dramatic extent, and the joint note by senior and junior counsel says this in paragraph 4. We are now jointly of the view that these grounds of challenge are more likely than not to succeed. And they go on to say, and I think this is at their conclusion, paragraph 31, or paragraph 30, the option is to concede the petition. The other option is simply to press on regardless. That is in many ways even less attractive. The expenses will be far higher and the trumpeting far louder if the case proceeds to a written judgment. And there's the real prospect of damaging criticism from Lord Pentland. And they conclude, our own view is that the least worst option would be to concede the petition. So why didn't the Scottish Government at that point take Council's advice and agree to concede?
Well, I'll come on to the point about councils. I will not comment on the trumpeting comment. I'll leave others to draw their own conclusions on that. All I would say, and people can decide whether it's in relation to that or not, is the more likely than not terminology that has been used publicly around this has always been attributed to the 31st of October. It's actually, you know, into the 6th of December. So in terms of law officers, you know, on the 11th of December, so again, I wasn't at this, but there was a meeting involving law officers, and the view of law officers, so in the days immediately following that, and remember, external counsel's views are important. We instruct them and we pay them. But in terms of the Ministerial Code, my duty is to make sure I'm abiding by what the law officers say. So what the law officers on the 11th of December, the opinion they were expressing is that there is no question or need to drop the case. The Lord Advocate was clear that even if prospects are not certain, it is important that the case is heard. Senior counsel made clear that his note was not intended to convey that he didn't think we had a stateable case. They tested most of the arguments, including the appointment of the IO, and concluded that we have credible arguments to make across the petition. So that was the view expressed by the law officers in the days after that opinion. So the charge that has been made against me is that I willfully allowed a judicial review to proceed against the legal advice, and therefore I broke the Ministerial Code. With respect, as you now know, I was acting in accordance with the views of the law officers, not acting against the views of the law officers. And you know, they come to these views taking account of external counsel's opinion and the wider interest. So, you know, the other comment you've seen, I think, from that discussion is the Lord Advocate being clear that we should not concede, with a stress on the benefit that would accrue from a judicial finding. A, that it was right to have a procedure in such circumstances, and B, it was right to have this procedure. So that speaks to that broader public interest that I was talking about. We thought we had a stateable case, and it's clear that counsel was not arguing at that stage. That changed later, but at that stage, counsel were not arguing we didn't have a stateable case. We thought we had credible arguments to make, and we were also taking account of that wider interest in getting a determination on the many grounds of challenge that Alex Salmond had made to both the procedure and to its application.
I think the reason I raise these issues and the reason they're relevant to this inquiry is that we were dealing here with public funds. Now, when the the concession eventually came, and we'll come on to that in a moment. The award of expenses was done on the highest level available to the court. And those expenses are only awarded, in the words of Lord Hodge, where the defence has been conducted either unreasonably or incompetently. So that's a really serious charge to lay against the Scottish Government and the law officers in terms of their conduct of this particular case. The point I would put to you is it was very clear by the 6th of December, if not before, that the risks of proceeding with this action were very high, and therefore you were risking public funds in continuing with the action.
So I think every time a government defends a legal action, it is risking public funds, because there is never a guarantee you're going to be successful. I don't want to keep going back to this point, but on minimum pricing, you know, if I had taken the risk-averse approach on minimum pricing, we'd have thrown in the towel on that before we got started. So, you know, there are sometimes good reasons why you have to defend in order to establish wider points. You can't do that if your case is unstatable, but if you think you've got a statable, arguable case, and indeed credible arguments up to the 11th of, or as late as the 11th of December, then I think that is the case. In terms of the, and I'll come back onto the issue of expenses in a second, but in terms of that, you know, taxpayers' money, and I feel very, very, very sorry for that, and I expressly said that earlier on. But we had a procedure here that was not just being challenged in terms of its application to Alex Salmond. It was a procedure that was being challenged in its fundamentals. And in terms of that wider public interest, including, you know, should we have complaints again that required this procedure to be activated, were we on solid ground using it? And that, so in the wider taxpayer public interest, that is not insignificant, I would argue. I'm not an expert, and I'm not going to pretend to be today on the reasons for the award of expenses at certain levels. My understanding is that, you know, much of what went really wrong in the case, catastrophically wrong, which then probably does lead to your characterisation there, was in that later stage of December when it became clear, I believe not intentionally, that there was information and material that hadn't hitherto been disclosed, and that changed, wasn't just very, very bad in terms of the duty of candour that is on litigants, but it was also the factor that changed that judgment about whether there was a statable case or not.
Okay, thank you for that. I mean, I do understand the argument that says it was reasonable to use public funds to try and push this, even though the prospects were receding. But of course, the Scottish Government did not, in the end, subject this to the judgment of the court, because the court reached no view on the basis of the policy. It was a concession on one ground. So the court never actually got a point to determine the issues that Mr. Salmond had raised. So you highlight what happened later in December. On the 19th of December, we have this astonishing note from senior and junior counsel. And I have to say, I've never seen anything quite like it in terms of what it says about the conduct of the case. The counsel refers to the regrettable way in which the document disclosure was unfolded, the extreme professional embarrassment that they have faced in court. They say that the behaviours who are cited for the commission hearing will expect a torrid time in the witness box. They say the late nature of the revelations are unexplained and inexplicable. There are acute difficulties to them in the way that they have on instructions pled the case. I mean, this is catastrophic, is it not?
That was catastrophic, and that's what led to the ultimate concession. So you're right that we didn't get to the point we wanted to get to, where we got a judicial determination of all the grounds for challenge. The point I'm making is that up until around that point, we thought that was a stateable, credible, arguable position to be in. That completely changed that. And for the reasons that you've set out there, that fundamentally changed the position in the court case. And had I, at that point, said, no, we're steaming ahead anyway, that is where I would potentially be sitting here with some justification, probably a lot of justification for the charges that are being made of me. But I don't think that is the case, because up until I've read out the position as late as the 11th of December. It was the opinion of law officers that we had a stateable case with credible arguments, and for that reason, as well as the wider public interest, we should continue. That you've described there was dreadful, catastrophic. That is the heart of what went wrong in the judicial review, and of course it then reflects what went wrong in the application of the procedure. And I'll defend our decision-making throughout this judicial review, including up to that, where it was right that the decision then followed that we would concede the case. I will not defend what led to that note, because I actually share your views of it.
So who is to blame for that?
Well, look, ultimately, you know, I'm the head of the Scottish Government, and you know, I am not going to sit here and start to chuck blame about in other directions. I was not involved in the investigation. I was not aware of the error at the time. But I'm the head of the Scottish Government, which is why I've apologised for it today. I think I apologised for it on the day the case was conceded in Parliament. And part of what we are doing in all of this committee being part of that, but the Laura Dunlop review that I've already spoken about, is trying to learn those lessons ourselves.
You've been very patient, Convener. I've got one more question, because I know others will want to come in. The former First Minister, in his evidence, claims that the Scottish Government only conceded the case when senior and junior counsel threatened to resign. Is that true?
That's not my understanding of the position. So this note came, I remember speaking, I think I was in London on that day, or the day after it might have been, but I think it was on the day that things were going very badly wrong. I was in London speaking to your former boss at the time, Mrs May, and speaking to the Lord Advocate on my way back up the road, when it was clear how much trouble at that stage the case was in. And I think I saw him in person the following day in this building. And that, you know, there was then a process over the next period when we reviewed. I mean, a government, even thinking we're in a catastrophe, you have to go through a proper process of review. The Permanent Secretary commissioned the note is a bit of a flippant word for it, the piece of advice from Sarah Davidson, which the committee has seen before now. And that then led over that, it wasn't the happiest Christmas and New Year period I've ever spent, I should say, to the concession of the judicial review. And, you know, do I think that is all deeply and horrendously regrettable? Yes. But what is regrettable is the error that then progressively came to light that got us to that point. I actually think the handling of the judicial review was legally sound. You can argue, people can take different views about whether all the decisions that were taken were the ones they would have taken, but the decisions taken in the conduct of the judicial review, in my view, were legally sound decisions, and they were taken in line with the views of the law officers, which, as far as I'm concerned, in terms of my responsibilities under the Ministerial Code, is the test I need to pass.
You have very skillfully avoided answering my question, which is, did the junior and senior counsel threaten to resign?
Sorry, I think I did. I'm not aware of them threatening to resign, but what I know is, and I know this partly as a former lawyer that didn't have that kind of experience or anything like it, but a lawyer will not carry on with a stateable case. With an unstateable case. That was a potentially catastrophic slip of the tongue. A lawyer will not argue an unstateable case. So the position of counsel at that point would have been, if we had said we're going to carry on with an unstateable case, I'm absolutely sure they would have withdrawn from acting, and they probably, I'm pretty certain they would have made that clear. But the way that is put forward suggests that we were going, no, we're going to carry on, and they had to force us into that position by saying that they were going to resign. The government was not going to ignore what was in this 19th of December note. There was a process of consideration and review that had to be done there, and that culminated in what you know off the back of the Sarah Davidson advice that came over the Christmas and New Year holiday.
Okay. Thank you, Convener.
Thank you. Now, I have a supplementary to what Mr Fraser was saying from Alex Hamilton, please.
Thank you very much, Convener. I'd just like to come in on the advice received from Senior Counsel at Halloween on the 31st of December. First Minister, you've compared another judicial review which had shaky grounds in the form of the minimum unit pricing. The difference between these two judicial reviews is that one is about public health and alcohol policy, and the other, at its heart, has two vulnerable human beings. I'm struck that when he laid out the options, Senior Counsel said that with an advantage of concession was that, and he makes the interesting suggestion that the procedure could be reset, safeguards put in place, and allow a renewed investigation of the complaints. So can I ask, at that crossroads, was the views of the complainers sought to inform your decision to proceed?
I don't think so, to be frank, but I would want to double check whether that was done in any way. It certainly wasn't something I did personally, and you know, is there an argument that should have been done? I guess that argument can be made. Can I say in using the comparison with the minimum unit price, and I'm not trying to underplay the seriousness of the issues here, and one of the things that I think is quite hard with this is when you're talking about litigation and legal, you know, and stateable cases, you kind of strip the actual human impact out of things, and I'm not intending to do that. I'm trying to describe. I'm not trying to describe to the committee the process of litigation. The committee knows that, but I'm trying to describe the factors and the tests that ministers have to apply and consider when we are taking decisions on the conduct. And so there are comparisons, even though the circumstances are completely different. So I don't think the complainers would have been asked their view at that stage, but I will check and I can come back on that more definitely. But certainly, and again, I don't want to overstate this as being a big part of the decision making, but I think in my mind, it would definitely have been the case that whatever you did would have an impact on complainers. So, you know, defending this, remember at a time when we thought we could argue this with credible arguments, that it might have been better for complainers for us to prevail that we had done this properly rather than put them through that whole process again. So these are judgments. They're not black and white.
The reason I ask is that the failure of the judicial review is one of the reasons that to this date, those two complaints have never been fairly or properly adjudicated. And you say, yes, every decision you took in that process would have affected the complainers. Did you consult them at any point?
I've not spoken directly to
the
complainers. I think you have heard evidence about points at which the complainers were consulted and spoken to, including by the Permanent Secretary, which of course is one of the points of contention in the judicial review.
In the context of the judicial review and the decisions you took?
I would want to check that. I am not sure of the answer to that. Okay. My apologies.
Thank you, Convener.
Okay, thank you. We're almost at 1:30, so I think this is an appropriate place to break in line with the agreed mitigations which are allowing us to meet safely in person today. So I'll suspend this session again, and I think we should reconvene at 2 o'clock. I remind members and everyone else to observe social distancing when leaving the committee room and during the break. I now suspend this session.